Okay, welcome everybody. Week 2. Any questions arising from the course thus far, from the website? No. Okay. Have posted some new stuff on News of the Week just this morning. And I'm gonna talk to this screen, if that's okay. And there is a whole bunch of new material. I'll talk about some of that and our first big post. Is everybody able to get onto the system? Has anybody not managed to make it on? We've added in a login button, which should actually work for everybody who's got a CWL account. So, so far I haven't heard any complaints. I've tried to respond to everybody. Everybody should have authorship rights on the website. If you don't, please let me know. Okay. So today we start moving away from introduction to the first meme of the course, which is creating. So roughly, the course is creating, connecting, and controlling. And then we do a conciliation or a reconciliation at the end. So we start tracking through the creative process. We then look at how in gaming and all digital media, the purpose is connection and what are the consequences of connection. And then we look at controlling, which is really a euphemism for how do you put the genie back in the bottle. And part of what I hope to challenge you with is this a genie we need to put back in the bottle? Let's talk about last week. Some follow-ups you might have seen. Matt, and there's been some excellent comments so far, took up the issue of is video gaming a sport or not. So I don't know if there are any further thoughts on that. Very useful analysis of how sports define themselves, and interesting from the perspective of the controlling meme, because sports tend to define themselves in terms of governing bodies, in terms of control, which is kind of fascinating. So as distinguished from a game, a sport becomes something that is organized. Excellent comment about sports being a cultural phenomenon and needing to understand sport that way. And then as to whether video gaming is a sport or not, I had a little inspiration last night, and I wondered to myself whether archery is an Olympic sport. It, in fact, is an Olympic sport, and I have posted 43 minutes from YouTube which you really don't want to watch, but I just did it for fun, of the Olympic finals of the team archery competition in London. And if that is a sport, it's hard to argue that video gaming is not capable of being a sport. It's 2 spaces elevated from darts, and I don't want to insult the dart lovers. So why does it matter if video games are a sport, or whether they're done in a sporting context? interesting situation with Super Smash Brothers earlier this year, where in a large gaming competition, Nintendo decided, and we never really found out why, but they at first asked that Super Smash Brothers not be a game that was used for the competition. It was actually the #1 competition stream. And then they quickly reversed themselves within 24 hours, and it went ahead. And whether they were objecting, the root of their objection would almost certainly have been IP related, but whether they were objecting because of concerns about violence or concerns that they weren't controlling the product, we never really got to find out. But it does matter. And I've given you the link there. Now, the other part of last week that I wanted to focus in on was this notion of evolution. And there's a really interesting paper. And the actual paper is down here. And remember, all this will be up on the website. But it's an academic paper that hypothesizes that we feel that we're motivated to play video games to the extent they allow us to sample our ideal self characteristics. Anybody agree with that? Disagree with that? Please.
I agree with that. I agree with parts of that. I didn't write anything on evolution, but I was planning to, and I never got around to it. I get the sense that our obsession with video games comes from our sense that we don't have as much control of the real world as we might like, and that this is a way of kind of sublimating that need. And it might be more of a devolution.
Well, I'll give you, I tend to agree with you. It's John T., right? Jeff. All right. Sorry, I will get names right eventually. I gotta. These pictures are not ideal. So it's Jeff. Okay, got it. So here's the deal on me. When I was 7 years old, I started reading Road and Track. That I talked to you about Grand Prix Legends last week. I am a terrible, terrible race car driver. And it's very, very clear that if I actually took up race car driving, I would not be standing in front of you today. There's no chance. But it does give me that sense of ideal self, of doing the things that I really would want to do. And the truth is, I don't play first-person shooters. And there's nothing about that I find attractive. I don't want to be in the Army. My 17-year-old son, though, does, and you get into these very challenging intellectual bifurcations as to, you know, does he love guns so much because he's been playing games that he shouldn't have been since he was 9 years old, or is it a genuine thing like cars is to me? So I don't know, but I do see this idealized self characteristic in both of us. And please.
Isn't the opposite just as true? That games allow us to play someone who's so completely different to us that it's fun. So being an evil character or playing a gangster in Grand Theft Auto or stuff like that, someone who's completely different from who we are in our world.
You know, we're getting into deep psychological waters about whether that's, you know, maybe a different version of the idealized self. That's a repressed thing. You get to do some things that you otherwise would hold yourself back from.
I think the way that they phrase it, we're motivated to play video games for this reason, I think. It sounds like a bit of a stretch. One of the, I think, most popular video games in general is just like the Jewel.
Yes.
Or something. So, I mean, there's obviously lots of other mental things that are going on for why we play video games, and this could be one element of it, but I don't think anyone idealizes themselves as dropping jewel upon other jewel.
No, I think that's obviously fair. I don't have to say I think that's fair. That's obviously fair. That's obviously clear. We don't play cards because we see ourselves as idealized jacks or kings or queens. I mean, that's a bit far-fetched. But, the paper's there from psychological science, and it's a real academic paper, and it's not long, and it's worth maybe a quick look at their methodology if you're interested in the area. But thought it was an interesting point from the perspective of if it is our idealized self that we're going after, that sort of contributes to the evolutionary theory. We're working on ourselves. We're trying to make ourselves better. So starting point for today. Are video games a mass media? Votes. Anybody say that video games are a mass media? Anybody say they're not a mass media? Nobody wants to say anything. When I started teaching the course in 2005, they were probably not a mass media. Today, I don't think there's any doubt if you look at the demographics and if you include all the different tools. I don't think there's any doubt they are a mass medium. Crosses all demographic lines and increasing numbers of women and girls. I can now see, our two girls who are now 15 and 11 never played video games until they got access to iPads and iPhones and portable devices. The Xbox was the exclusive purview of their brother, and PC gaming was my territory. But now they play games. I won't say as much as anybody else, but a fairly significant amount. Brilliant paper. That is the only paper, the only bit of material that you won't find on the website. Oh, by the way, just very briefly on the website, I've added a feature at the suggestion of the Center for Teaching, Learning, and Technology for the benefit of your papers. I have to populate it, but you will now find that under the syllabus, there's a main syllabus and then a breakdown, a pull-down menu where you can go into every section of the course. The only difference between the pull-down section and the main syllabus right now is nothing. The addition of a couple of words called additional materials. But the idea is that I will start populating the additional materials with all of the links from the lectures and news of the week stuff, and so that you can actually start as a base point looking at a topic and seeing, even if all the material is somewhere on the website, you'll at least find one more cross-referenced version of it, which could be helpful. In any event, this paper, because it's written in what I would call the internet dead zone. We had an internet, but academics were not publishing to it. And I would call that sort of roughly 86 to 94, 95. You'll find a lot of academic stuff that you won't find anything but a hard copy of. And this is, ironically, one of those by a journalism professor by the name of Shaw, The Rise and Fall of American Mass Media. Brilliant, brilliant paper. It is on reserve in the library. You don't have to go there because it's not video game law per se. fascinating conclusions based on real research and data. The first, which won't surprise you, is that no medium, no mass medium, once it's lost its dominant position, ever gets back to the top. And you got to remember the timing of when this paper was written. 91, what Shaw was looking at was a transition from newspapers to radio, to television, to the coming of cable television. That's what he was focused in on. He was not focused in on the internet. He was not focused in on video gaming. What was so profound about the paper and about his conclusions was, although once a mass medium lost, was eclipsed, it never got back to the top. So newspapers never caught back up. Radio, once television came along, never caught up. They flatlined. They didn't actually decline. Their revenues, their circulation, their penetration roughly just flatlined. So what you have, and if you think about this over the course of the 20th century and the early part of the 21st century, and where we are now, and you think about it in the context of gaming, is you just get this layering of media, and it just keeps building and taking up more and more of our lives. And in that context, video gaming's role is pretty clear. It may not be deep except to some of us, but it's now pretty well a layer in everybody's life, thanks to this and a bunch of other things. And it's hard to know what will eclipse it. The only thing that we can guarantee is that it will be eclipsed. Now, the one thing that Shaw's paper, and this is a small point, but it's a fascinating point. It's fascinating to read something that is absolutely brilliant from 1991, but that never foresees the audience's creator. And that will be a theme, a theme of the course for sure. Now, so what kind of media is video gaming? So I'm just going to throw a couple of things at you. And the first is to suggest that video gaming, rather than, there's a lot of really interesting academic stuff around video gaming. I don't know if you guys know, but there's a huge academic infrastructure that has developed really in the last 10 years at schools all over North America and many in Europe, of non-lawyers, of sociologists, of some technologists who are writing, and there's journals just all about video gaming. And there's a school called the Ludogical School, which simply suggests that video gaming is very different, not shockingly, from writing a book, because it's nonlinear, because it involves the audience as creator, and so there's a search for what's the right paradigm. And so one suggestion is that video gaming is really a successor to the oral culture. It's oral storytelling more than it is written storytelling. And that makes sense as far as it goes. Those of you who have taken intellectual property law may know that, and if you don't know, I'm about to tell you, that because of the requirement in copyright law for fixation. So the key moment, well, I'll go back one step. There is no copyright in an idea in our Western canon of intellectual property. If you have an idea, and we'll talk a lot about this next week, but if you have an idea, anybody can do anything with it. It's when you fixate the idea. It's when you put it on paper. It's when you memorialize it in some way that it attracts copyright. This is a very difficult concept in an oral storytelling culture. So indigenous peoples around the world and certain in certain Norwegian countries, which are heavily oral storytelling based, there's real tension around intellectual property law because it doesn't make sense in that idiom. And a lot of what we're going to talk about today is what makes sense and what doesn't make sense. And I apologize. I'll have to revise that. I left that. That was my original word, but I've replaced it with IP dystopia because I think that's a better way of putting it. There's an entire school of video game academics. There's more than one article about this that suggests that the one author who wrote video games as literature, or whose literature used the same or exposed the same methodologies as video games, was James Joyce. Absolutely fascinating. And well worth reading this short article by Alistair Brown. But we still I guess the only thing I'll point out is this notion of hypertextual fiction, that when you're reading Ulysses or you're reading something by Joyce, you are jumping around to all parts of the story, and you're constantly trying to incorporate things that you've read elsewhere to make sense of what you're reading right now. And that is very much a video gaming idiom, not for Bejeweled. And you know what, I think we have to, and that really sort of sharpens my saw, is to, we have to contrast the video games that are trying to tell a story and the video games that are more like games. So we keep being left with this really recurring theme. Where are we going to find the fixation we need for copyright? And this core, and do we need it? It's actually the more important question. And does it really make sense? So there's this great tension between these storytelling modes that jump around all over the place and involve the audience as the teller of the story, and traditional linear requirements of intellectual property and copyright law, which are based on story that has a beginning, middle, and end, written by an author, read by an audience. Now, Ken will tell you that nobody, and I agree with them, nobody just reads a book. If you're just reading a book, you're not going to like the book. We are participants in what we read. But it's all happening up here. So the fixation issue never actually gets joined, because it's all still in the realm of ideas. So now I want to start approaching this tension a little bit more directly. First copyright law case, so far as I know. And that is Donaldson and Beckett. House of Lords case, 1774. denied the continued existence of perpetual common law copyright. Underline perpetual in your mind, please. So the original common law notion of copyright was that the author had it forever. It didn't fall into the public domain at any point. The Statute of Anne comes along and limits it to 8 years originally. 14? And the court in Donaldson and Beckett wrestled with, what do you do with this statute? And because we have a common law, and the court went with the statute and said you could have a term limit. And now you guys may have read or heard a couple of years ago in the United States, kind of what were called the Mickey Mouse laws, trying to extend copyright term beyond 50 years, et cetera, et cetera. It's always very interesting. Once a year, you'll see articles, and I hope I catch one or two so I can put them on News of the Week, that give you the list of works that are no longer copyright protected. Because we're now in the zone after 50 years where pretty interesting stuff starts becoming available every year. Oh, sorry, please.
Interesting article that I read recently on one of the blogs about whether or not there will be agitation to yet again extend copyright term extension in the U.S. now that Mickey has had his 20 extra years and is coming back up for possibility of slipping into the public domain.
It becomes huge efforts by Disney and others. I just want to mention a wonderful draft book chapter that is really great reading by Professor Greg Listoka. It's up on News of the Week. It's also available here. I snuck it in, which I know is cheating, and please forgive me, because that's where it belongs in the introductory section of the syllabus, which really was last week. And Greg is our guest next week by video conference in the second hour. And he's going to talk about user-generated content, which is where he ends this chapter. This is a book. This is someone else's book, and he's just done a chapter on sort of the history of video gaming law. And it's excellent and just a great starting point for almost any paper that you would do in the course. Speaking of which, I hope you guys noticed I did create a paper talk section of the blog, of the website. So if you go to the website, you'll see a header that says paper talk, and that's where we should all be contributing paper ideas, and I recognize that a lot of that is on me. But I'm hoping Ken might get online and throw a few things in there as well. Interesting piece from TechDirt if you're interested. But the focus is this tension, this dystopia around copyright and what gaming is. So now we get to the soft underbelly of the beast. Not a video game case, but Universal and Sony, 1984 U.S. Supreme Court. Is anybody here born in 84? You don't have to answer that question. Okay, thank you. I bought the first commercially available, or within a year, Sony Betamax machine. And they were quickly eclipsed by other kinds of VCRs with a slightly different format. So somewhere I think I've still got some original beta tapes, and I would have had to crawl around too much to find them for you, but there's at least the picture. Giant honking machine, cost about $800 at the time. We're talking, I think I bought in 82, 81, 82, here in Vancouver. I think it cost about $600, or it was like the first cheap, attainable Sony machine. And what this raised, so this allowed for read-write. This allowed you to tape TV shows. I know it's inconceivable that there was a time where nobody could tape TV shows, much less, okay, you guys don't tape, you're just on the internet, or what am I, Operation Free TV or something like that. So you're so tuned into this on-demand world, but it used to be that you actually taped this stuff. And the other thing, and I know Ken can verify this with me, you would not believe how complicated it was to actually try and set the timer to tape something. It was virtually impossible. I never did it successfully. Never, ever. You had to put in actual numeric codes into the system. You never got them right. They were about 16 numbers long. Why they were trying to put in encrypted numbers at that point, who knows? They weren't, but it was a ridiculous exercise. So the only time you ever taped something was when you were watching it and you thought you might watch it again. Because I'm not even sure at the time whether you could tape something on another channel in the original. Yeah, so Ken's saying no, you couldn't. No, so you couldn't even tape.
The original monitor.
Yeah, you could only tape what you were actually watching for reuse. Or if you set it, you could watch it another time, and that's the thing. So obviously, as this technology came to be, the producers of film and television. And the other thing that you don't see so much today that was quite prevalent back then was film events that had been in the theaters, say, 3, 4, even 5 years earlier. The first television premiere of a big film was a huge deal on television in the 60s, 70s, and 80s. It was water cooler talk.
And Disney used to, and still does, but what Disney would do would be to put the film in the vault. You'll still see the occasional commercial for this. Taken out of a vault, Tinkerbell finally shows up yet again, or Bambi, or whatever. And they basically had a marketing program that they would release the thing back into theaters for a piece of time, and then they would take it out of the theaters, and nobody had access to it until you started to be able to tape things. And once you were able to tape things, there was a way to subvert that. And that was one of the major problems. The other thing that we should remember is in the early 80s was when Japanese cars were making huge, huge inroads into the U.S. economy. And there was in Detroit, they were actually burying Hondas. Or in those days, I think it wasn't a Honda, it was a Datsun. But, they would dig a grave and they'd throw it in because there was such damage to the U.S. car industry. There was a lot of anti-Japanese feeling, which it's been suggested fueled much of this particular case between Universal and Sony.
So to add one more thing to this, and I know this is so inconceivable from where you sit here in 2013, the VCR gave the consumer unprecedented amount of power for that time over their entertainment offering. I know it seems incredibly limited today, but if you look at it, this is the beginnings of user control, of consumer control. Previous to that, and you go to the movies when they tell you the movie is on, if you're going to the theater. But before that, you could only watch television at the appointed time. So into this comes this machine, which clearly copies the content. So must be a breach of copyright. So Universal is a big film company. It takes on Sony. And now you've got the joinder of the issue that we're talking about. You've got IP law, which works in a linear author-based environment and where everything is controlled. And you have the question of consumer use, consumer control, consumer contribution, which here is limited only to, I don't want to watch this now, I want to watch it later. And the US Supreme Court wrestles with the issue and decides that time shifting is fair use under copyright law. We call it fair dealing in Canada. It's fair use in the States, if you want an easy device to remember that with. The first two letters of use is US. So whenever you're talking fair use, you're talking US. Fair dealing is the Canadian concept in our Copyright Act. And so time shifting was not a copyright infringement. This was a radical, gigantic departure, and an awful lot as we look at video gaming, as we look at digital media, hangs on that decision. And there's a number of other cases involving music, the Grokster decision that you should look at. But on the video side, I've given you a Court of Appeal decision, Fox versus Dish Network, which is the same issue updated to today, which is a box that allows ad skipping. And Fox sues Dish Network for putting this box out, and the court follows Universal and Sony and says, no, consumer control, consumer choice, that works. So, come on, please. This is not a new phenomenon. This is like every year. I can never get the technology to work. So what is this dystopia I'm talking about? The definition of dystopia is an imaginary place where people lead dehumanized and often fearful lives. So what is copyright or IP dystopia? It is that people don't know whether they're breaching copyright or not. And your generation, not all of you, but largely, your coping mechanism, in my judgment, is, yeah, we don't care so much. We know we're doing the right thing. And it's interesting because the courts are tending increasingly to agree with you. And the Supreme Court of Canada last year, in 5 cases that are known as the pentology, which we will dig into over the course of this course, really agreed with you, except for the minority. But you're going from gut. On the website, you'll find an exchange that I had with a colleague from the Center for Digital Media, which I just show it to you so you can find it. But he's a creator, and it's a funny exchange, but he really is lamenting that not knowing what the law is impacts creators much more than anything else. And we're going to talk a lot about remixing, because if you think about gaming, whether you're authorized to do it, because clearly you are, but you are remixing within the context of a game. And when you're talking about modding or building levels to a game, to an existing game, you're really doing that. But this really focuses on that outside of this room, outside of lawyers who say we know, it's almost impossible for the rest of the world to know what to make of intellectual property limitations. And it certainly affects the creators, and it affects others as well. So what that leads to is the core of the course. How do we remix laws into virtual digital environments? And I have not sought today to do anything but give you the merest of introductions to the tensions. But a large part of the course is going to look at the tensions. I'll tell you exactly where we're going. There's no reason to hide it. We're going to explore the tensions between intellectual property law and freedom of expression and the freedom to create. And we are going to lament over them, navel gaze over them, make some progress on them, possibly reconcile parts of them, and then realize that there's a giant bait and switch going on. Because copyright law is not copyright law at all. It's been switched out on us by end-user license agreements and contract law while we've been sleeping. And all of those agreements that you don't read and agree to have reformulated what the intellectual property constraints you're operating under while you play a game or while you engage in digital technology actually are. So some of this academic discussion of the tensions between copyright law and user-based, creator-based, interactive digital media is kind of academic right now. And the larger tension is it is becoming whether contract law is pushing copyright law out the door. And where, well, I'm not even going to tell you where, I'll prove it to you. But we'll get there. Any questions about anything so far? Okay. So the traditionally formulated question in a legal environment is, all right, how do we apply real-world laws to virtual environments? And Duransky wrote a book, and the answer is, okay, we've got to we've got to create something called the magic circle, which exists within gaming. We need to protect that so people can have fun. I will argue increasingly, I'm actually going to do a talk next week at Georgia Tech on what I would call the diminishing magic circle. Because the magic circle isn't as big as it used to be and isn't so magic anymore for a variety of reasons that I'll enumerate and to you. But the traditional notion is, okay, let's protect this circle of stuff. Let's not let law in there. And then let's make sure that law applies as it needs to if something's going really wrong. You know, if a drug deal is being made through the voice IP of Call of Duty, the fact that it's done by two kids wearing headsets and playing Call of Duty doesn't diminish from the fact that a criminal law is being broken and there's no protection from that. So you get these traditional tensions, and where in 2008 Duransky did, I think, such a good job was identifying that as game designers and as the digital world starts to use real-world economies and money, and think of in the current idiom gamification, freemium games, and the fact that you're doing real money transactions. I don't know if anybody saw, but Xbox and Microsoft has just switched over the Xbox Live account system from points to money this week. So what we're seeing, and what Duransky starts pointing out is, well, if you're going to start introducing real-world elements, then real-world laws are going to apply more and more. And the magic circle is going to shrink. And I certainly agree with that. Then, as mentioned before, the real world becomes even more real when you start introducing contract law into it, especially 30-page end-user license agreements that are very real world, entirely real world. Okay, so now I want to take you to the beginning of this tension. Ooh, I skipped.
Yeah, just jump.
It did it itself. Oh, well, maybe the NSA did it. Sorry. Sorry, guys. Bruce Boyden, brilliant paper. Games and other uncopyrightable systems. Games in this paper does not mean video games. It means games. Card games, hula hoop, competitive hula hoop, I guess. Games means games. And games are among the things that don't attract intellectual property copyright protection. So get this really clear in your head. There is no copyright in fish, in poker, in bridge. There's no copyright in games. What Boyden questions is maybe there should be, but what he really digs into is the fact that there's intellectual property protection. That there's intellectual property protection for all aspects of games. There's trademark all over the place. There's design stuff. Think of Monopoly. So, Boyden raises the issue that even if there isn't copyright in a game, we're living in this kind of false world because makers of games have all sorts of other protections. And he basically raises the question of what we should do about it and what we shouldn't. But the core tension for our purpose is until you add the word video, there isn't IP protection. No protection in the game. So what really happens? And what I'll try and show you in the next 10 minutes in various ways is that it's the art part of the game that starts attracting the copyright, not the game part of the game. And briefly talk about whether that's a good thing or a bad thing. So the case is the case of Breakout. This is the one that exposes the issue for good and bad. And you will decide for yourself what's good and bad here. So anybody, well, Breakout has come on a variety of mobile devices. So I'm assuming you guys know what happens. These are bricks. As you go, as the ball hits a brick, it removes it, and you get to this wonderful moment if you angle it right, and you can get behind the bricks where it takes out bricks from behind, and you don't have to worry about hitting the ball with your paddle for a while. And it's very exciting. So that's the game. This is the case. Atari and Oban. Sorry for all the verbiage. I warned you about that last week. At first, you will see the court's description of the game. And there's all of the references to the actual cases. There were two kicks at the Court of Appeal that were taken by the Register of Copyright. And in the second one, and I may allude to this towards the end of this talk, the court tried to be funny and put things in sort of a game idiom in their decision. The core of the case was that when the makers of Breakout tried to register the game for copyright protection, the U.S. Register of Copyrights refused to protect the game and refused to allow a copyright registration. And the reason given was that it was too simple, there was nothing original, it didn't cross the creative threshold. And so you may say to yourself, those of you who've taken IP law before, and even those of you who have not, gee, I thought the threshold for copyright was really low. I scribble something down on a piece of paper, it attracts copyright. How can Breakout not be copyrightable? Well, the Register of Copyright kept on refusing. And it started becoming quite clear that this was like the sport issue we talked earlier, defined in cultural terms. Gaming in the late 80s, mid 80s was not mainstream, was not accepted as art, was highly pixelated, and the Register saw it as a game but didn't see the art. And the crucial question, which is unfortunately only found in a footnote of the Court of Appeal decision, to me was the district court judge asked the Register of Copyright on the stand, because the Register of Copyright was just objecting that these are just basically square objects representing round objects, and et cetera, et cetera. If Picasso had painted a round object on canvas, would you say because it depicts a familiar subject, namely something that's round, it can't be copyrighted? And the Register of Copyright had to say, well, of course it could be copyrighted. It's Picasso. And that really was the end of the case, because the court clearly was going to say, we're not going to distinguish between Picasso for the purposes of the law, we might for the purposes of our art collection, and the creators of Breakout. and ordered that copyright attach, and the register still came back, and the court had to decide it twice, once in '89, once in '92. That's how stubborn they were. And so you will say to yourself, vindication, games are art. And I just want to remind you that that can be a two-edged sword. Comment and hit the button, and please be brief.
Yeah, one of the things to remember is this is the time when the United States decides to finally let go of the Universal Copyright Convention, which held a large number of formalities in order to attract copyright for anything. And there were renewal periods, there was all sorts of things that had to be done, and they only became Berne signatories in 1989. So it's right at that critical time. At this particular time, you have the big American case in copyright before that. It's Baker and Selden, which had to do with a series of colored bars and is often used to discuss the distinction between the idea expression dichotomy. That was the earlier form of copyright. But when they adopted the Berne Convention, that's when the threshold, particularly in the US, but also in a number of places, is lowered to, of originality. It just has to originate with a particular designer or person, author.
And next week we're going to talk a lot about the idea expression dichotomy and about those thresholds. But for today, these are just, the Museum of Modern Art has last year created an exhibit around video games. So again, reinforcing games as art, attracting intellectual property protection. Amazing YouTube, it's on the website, by Paola Antonelli, who's the curator of the Museum of Modern Art, talking about her process when she wanted to create and curate a show at the Museum of Modern Art about games, and all the raised eyebrows and all her reasoning. She's fabulous. It's an awesome piece. Please watch it. William Ford, who's a law professor, did the academic part of this, which you could explore as well. But this choice, this bifurcation, games, video games, video, art, copyright, games, no copyright. This bifurcation has all sorts of consequences. For the next 3 or 4 minutes, we're just going to talk about a couple of ironies. For the rest of the course, we're going to see the consequences. So, yay. We're vindicated as gamers. We got legal recognition. I thought this was a great thing. When I wrote the book in 2005, I was giving talks about, how stuck up people and registers of copyright and, refuse to recognize gaming. Well, today, nobody doesn't recognize gaming. There was an issue underneath that I didn't see, and it's the IP dystopia issue that I've been referring to. So with it came the limitations of IP law that we will be exploring. And I just want to point to a moment, a legal moment. The case of Stern and Kaufman was a scrambled knockoff case. And the defendants, who had knocked off another game, threw in everything but the kitchen sink into their arguments. But the argument is, I want to note this argument. Each play, this was the defendant's argument, each play of the game is an original work because of the player's participation. Each play of the game is an original work because of the player's participation. The court said no. In '82, and by that hangs the history of video game law. By that thread, for the next 11 weeks. So please note it. So player participation, the argument meant that something couldn't be fixed. If there's no fixation, there's no copyright. The court said no. Somebody conceived how the game would go. And you got to remember, back then in the late 70s, early 80s, games really did have a very narrow framework and a narrow series of options. So pop open your mind to today, where you've got massively multiplayer, open world, totally open world games, effectively, that replicate themselves in new ways as you expand across the territory. This is a game that's under development that I know well, and I have permission to use that slide. That is one of those massively online games, and of course Minecraft. Limitless. Created by players, created by users. Someone first conceived what the audiovisual display would look like and sound like. Originality occurred at that point, therefore intellectual property protection occurred at that point. Very useful, logical in 1982. Query its applicability today. Next point, again, originally jumping up and down. We've got respect, we're gamers, finally people recognize what we're doing as being legitimate. With that legitimacy came new layers of issues, mostly around violence. And we'll explore that in detail over the rest of the course. Lots of blame issues, not a lot of data. I've put a reference into what the NRA did in the wake of the tragedy in Newton, where basically the argument that was made with a seemingly straight face was that digital games were more dangerous than real ones. And that's just wrong on every level. And then we get to double standards. And the double standards that I really want to talk about is when we look at gaming and violence in games. It's interesting, we've got academic studies, but there don't seem to be similar academic studies on the effect of high school football or ROTC training. And only recently have the scandals of sexual assault in the U.S. military made it to where they are. And you have to ask yourself whether those environments are conducive to that behavior. And because people are only too happy to ask whether video game environments are conducive and help create bad behavior. And then for your amusement, we'll talk a lot about EA and Zynga and plagiarism in a different context, but it's an interesting reference point because gaming companies don't always respect each other. I'll leave it at that for now because we will be talking about it week 9 or 10 in some detail. But talk about real-world spillover, a main Democratic candidate criticized for actions in World of Warcraft. So a political candidate who happens to be a dedicated World of Warcraft player, her World of Warcraft activities became the subject of scrutiny as she was running for a real-world election. What her character did in World of Warcraft was seen as relevant. So decide for yourself, but more than that, look at the double standards, look at the question of whether gaming got respect. Ask yourself, quite seriously, if you had Otari and Aman, and you could decide it any way you want, knowing what you know today in 2013, how would you decide it? Next week, we will talk about idea, expression, dichotomy, and where it leads us, and what the dichotomies and paradoxes are. And Rock and I have to do a switchover of technology. It'll take us about a minute, so hang tight and we'll get it done. Rock, you're on. So I would just like to briefly introduce Rock Ripley. Rock is at Gowlings, so you want to know him for a whole lot of reasons. He is also a great friend. He is co-author of the second edition of Video Game Law. He is a patent lawyer by trade and one of the smartest guys I know.
Oh, well, thank you for lowering the expectations appropriately. I'll start. I walked in right when you were talking about getting protection for games, and I restrained myself from interrupting you mid-presentation. I mean, my personal experience, I drafted and obtained patents for video games. With that being said, I don't think it has to be a video game to get protection for it, to get patent protection for it. You could have a board game. There's a very famous case, at least in the patent realm in Canada, where somebody tried to patent a new way of playing poker in a casino. It ended up not being allowed for kind of questionable reasoning, but the reasoning doesn't preclude non-video games from being patentable, period. And the corresponding patent was in fact issued in the United States. In fact, before coming here, I tried to find that patent for that game Deal or No Deal. You ever watch that? That was a few years ago with Howie Mandel. I used to love that. I couldn't find it now, but it is in fact a patented game, and you can still play the Flash game. It's online. So I don't recall if the patent itself is limited to the video version, because of course they sell these games at Toys R Us, so you can get your kids hooked on Deal or No Deal at a young age. The patent would not necessarily, I think, have to be limited to the video version. So there are other ways to go about it. Now, with that being said, there we go. I'm not here really to focus just on video games or patents. Today I'm here to talk about basically two things. One, the intersection of contracts and IP law as it applies to video games, and two, patent trolls as they are currently suing the video game industry, and a little more broadly, the software industry. And of course, there's incredible overlap between those two realms. Why these topics? One, maybe you'll be inspired to have some kind of interesting paper idea. Two, more sort of academically or pedagogically, consider the degree to which you have private law modifications and exceptions to the statutory IP laws that have been debated and that have evolved over hundreds and hundreds of years, and whether or not your quick I-click or your quick click to agree should be sufficient to undo hundreds of years of statutory evolution. So a starting point, before we talk about contracts and terms of use, and I apologize if I'm repeating a lot of what John said, let's begin at the beginning. So where are we before we modify anything with contracts? One, I walked in when John was presenting this. Games are protected by copyright, not just video games, but games generally. And that's Atari v. Oman. That's one of the cases that says it. Another aside, there are reasons why you would want to protect any kind of product, including a video game, with several forms of intellectual property. They all protect a different aspect of the game. One of the slides I often include, I didn't include in this one, is showing how the different IP rights overlap and don't overlap. So if you have a game You can have the trademark in the game, which protects the brand. You can have monopoly. You can have copyright in the game, which protects how the artwork on the board, the artwork and the pieces, how they're designed. You can have design rights, which actually the design rights would be better suited to protect the three-dimensional pieces, whereas the copyright would be better suited to protect the layout and the graphics you've shown on the board. You can have patents, which actually protect the rules by which you play the game. They are all directed at a different aspect of the game, some of which overlap, some of which don't, and they all have their different purpose. So,
And just to clarify and make sure it's clear in everybody's mind, there is no copyright in game per se. There's all sorts of copyright in the artwork and the writing.
Yeah.
Then there's trademarks over over various design elements. There might be even patents over design elements. So when you're talking about the video game, you're talking about intellectual property protection over the whole project. And the article I referred you to talks about the fact that in the pure aspect of a game, there's no copyright per se.
yeah, that's right. So you've got this underlying work, the video game that is protected by copyright. Then how, what are the exceptions to that? That's how law works. There's never one clear-cut rule that applies to everything. So one exception is reverse engineering is okay. And there are a couple of cases there, Atari v. Nintendo and Sega v. Accolade. The first one actually, it was held in that particular case that reverse engineering there wasn't okay because Atari had, or was it Nintendo? I'm confused now.
It was Nintendo.
Was it Nintendo? Nintendo that actually came with, okay. So Atari had copyright in a game. The code was publicly available because they had applied to register the work in the U.S. And actually, it was probably Atari because Atari is the plaintiff.
Oh, you probably right. Sorry.
Yeah. So Nintendo would have had copyright in a game. They would have made that code available by virtue of registering the code with the U.S. Copyright Office. And Atari said, we want access to the code to do certain things with it, to be able to act in a way that is equitable and fair. But in fact, they had misrepresented what they were doing, reverse engineered the code. And at the end of the day, what they did was not permissible because they had come with unclean, dirty, bloody hands. There's the Sega v. Accolade case, which where Accolade was found to have committed permissible reverse engineering. So I don't know if anyone here actually owned a Sega Master System. Anyone own a Sega Master System? Welcome to middle age, Rock. I owned a Sega Master System, and anytime you booted up the Sega Master System, you had the Sega logo come on the screen. It went boop, 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 and then you started to play the game. And one of the things the Master System did when it did that logo was it was checking to see whether the cartridge you put in was licensed by Sega. So there was some code behind the scene that said, are you a licensed product game? And the game would respond to the Master System and say, yes, I am, let me play. And you would be able to play.
Atari was trying to break into the Nintendo system.
Okay.
So it was that, but the reason they were the plaintiffs is because there were antitrust aspects to that.
Okay. So in the Sega and Accolade, it was definitely Accolade that was trying to access the Sega system, and they had tried to reverse engineer the code on the Master System to let Accolade games be played on the Master System without actually taking a license from Sega. There, they acted appropriately, and the court found that reverse engineering for that particular goal was okay. They didn't violate copyright law. Another exception, or not an exception, but another variant of the general rule that copyright does subsist in video games is enhancements that don't create a derivative work don't infringe the underlying copyright. So does anybody remember the Game Genie? Not that old. So there's the Game Genie. It was this thing. For those of you who didn't use the Game Genie or don't know it, you would take a cartridge. That's something you played games on before discs. You take a cartridge, you would insert it in the Genie, then you would insert it in the system, and the communications between the cartridge and the system would be modified by the Game Genie to let you do fun things like get unlimited lives or never die or skip levels, et cetera, et cetera, et cetera. And there, a court, after being after Galoob was prodded by Nintendo, and Nintendo was saying you can't do this to our underlying hardware and software. A court said actually they're not infringing your copyright. They are enhancing the game. They're not creating a new work based on the underlying game. So there's no derivative work. So there's no infringement. So you can keep on selling the game Genie. That's a specific example of the general rule that if you have a fair use, as it's called in the U.S., if you're using a copyrighted work for fair use, what you're doing doesn't constitute infringement. It's an equitable doctrine, which is why when Atari tried to rely on it and they had misrepresented what they were doing, they weren't able to rely on it. They had the Lady Macbeth problem. And then finally, it's the common law. You have what's called copyright exhaustion. If you have copyright embodied in a product, and then I sell the product to you, and then you go and you use the product any way you want to use it, I can't then sue you for copyright infringement because I have sold the product to you. As soon as I make that sale, the copyright rights have exhausted. I can no longer enforce them to you after I've sold them to you. So that's sort of your starting point before you have to think about how a contractual private law framework overlaid on copyright statute and jurisprudence modifies things. And then we get into a variety of cases where all those general rules are modified by end-user license agreements or terms of use, or just basically contracts that have been agreed to by either the gamer / licensee and the rights holder / licensor. So one of these is in fairly popular or famous case. Have you talked about Davidson yet?
I have not talked about Davidson.
Okay, so one case that I'm sure John will bring up a little afterwards.
Many times.
Many times. It is Davidson and Associates, the Internet Gateway. The citation is there. In this case, you had Blizzard, which is a very active litigant, and they have this multiplayer online platform called Battle.net. A big problem is software piracy, and at least several years ago when people were trying to combat piracy, we were thinking, how do we do this? I mean, we release these CDs, they have CD keys, but people just share the CD keys, they end up playing the game for free. How do we stop them from playing the game for free? And the answer was they would have Battle.net, which means after you bought the game, you'd have to log in if you wanted to really enjoy the game to beat up all your friends. You had to log on to the Blizzard server, and when you logged in, they could confirm whether or not you had an authentic version of the game. So what some gamers did, and not with the intention to circumvent, or not with the primary goal of circumventing the protection that Blizzard had engineered, but what they did nonetheless was they established a competing, unauthorized Battle.net service. And the secret sauce that Blizzard used to implement this protection, this authentication mechanism, they didn't have. They asked for it from Blizzard, and they didn't get it, and so they didn't implement it. So on this competing platform, anybody could log in and play authentic game or not. And Blizzard was not pleased. So Blizzard sued them. And they sued them for, for several things. You sue everybody for everything if you're going to sue somebody. But so some of the reasons they sued them was for breach of contract. And the contractual terms that these people had agreed to include these. So you are not going to, in whole or in part, blah, 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 reverse engineer, derive source code, modify, disassemble, blah, 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 derivative works based on the program. Also, you're not entitled to host or provide matchmaking services. That's what Battle.net was, a matchmaking service. For any Blizzard software programs or emulate or redirect the communication protocols used by Blizzard as part of Battle.net. Fairly clearly prohibited what these gamers were doing. So what happens at the end of the day? The court says, you've agreed to these contractual terms. You may have had fair use rights had you not agreed to these contractual terms to modify and reverse engineer the Battle.net source code or whatnot. But you did agree to the terms. You've contracted out those fair use rights. Therefore, you can't rely on them and you're liable for them. Also, something that's important when you're talking about video games today is the DMCA. It's not a contractual right, but the Digital Millennium Copyright Act, which says over and above copyright, which of course you can only infringe by copying, if a rights holder has protected a copyrighted work using some kind of digital lock or digital key that prevents access to that work, you can also infringe the DMCA if you circumvent that to get at the underlying work. And they were found liable for that as well, because that authentication mechanism, that CD key that Blizzard was saying you had to input in order to play the game, which you didn't have to input in order to play on Battle.net, circumventing that was a violation of the DMCA. So they were found liable for those reasons. Probably a few others that I haven't listed on the slide. Probably. But at least those.
No, you got the main ones.
Those are the main ones. So another Blizzard suit happened a few years later, again with Warcraft. And another issue that arises with multiplayer games is that playing them takes a long, long time. And a lot of it is kind of rudimentary. When you're learning to play the game, you want to do things like collect gold or build up levels or do things that take a while but may not be particularly exciting. And one guy saw an opportunity here, and he said, I'm going to create a bot, which is a little automated program that goes around and plays the game for you. You can buy the bot from me, and then when the bot has got you to level 1,000,000 with a golden diamond sword, you can then take over your game and then start kicking ass and taking names and doing whatever else you want to do with your powered up character. Blizzard doesn't want people to do that. They want people to actually play the game. You know, in no small part because I think you want a level playing field when you have a massively multiplayer game. You don't want, 25% of the players all at level 1 billion with no sweat, blood, effort, or tears, and you don't want those 25% killing your 75% honest gamers.
And the honest gamers also don't want.
And the honest gamers don't want.
So when we say Blizzard doesn't want them, to some extent here, Blizzard is standing in the stead of the gamer, of the user.
Yeah, I was saying Blizzard doesn't want them because Blizzard actually sued. But if you're in that 75% that has spent a lot of time playing the game properly, you also don't want to get killed by a guy who, just came back from work after the bot played for 10 hours. So the program that Blizzard incorporated into Warcraft to stop people from using bots was called Warden, and the bot that this guy created that outsmarted Warden was called Glider. And of course, Blizzard had in their license agreements with players language that prohibited people from using Glider. Language like this. No cheats, bots, mods, hacks, third-party software, etc., etc. So the maker of Glider and Blizzard go to court. The maker of Glider, by the way, was dumb, very, very dumb. He would post things on his website like, what he post? Stuff like, I make Glider, I know it's bad. Basically, without much hyperbole, I know this is bad, I don't care. Here's Glider, haha, Blizzard, haha. That's very little exaggeration. That's what he would post. So tell your clients not to do that. And what happened at the end of the day. So fairly clearly, there's a liability for breach of contract that, on its face, contravenes the contract terms. It's a violation of the DMCA as well. The violation there was for the access control provisions, which is what I talked about earlier. There's another section of the DMCA that deals with copy control provisions. So not controlling access to the copyrighted work, but once you've got access, controlling whether you can copy it. And further to what John said in the portion of the presentation I saw about how each game plays an original work, the court here talks about how when you're playing the game, you have dynamically animated characters. And that dynamic animation that you can access without actually, well, that's distinct from the copyrighted characters that are accessible on the CD without playing the game. So there's the copyrighted stuff that's generated while you're playing the game, and there's the copyrighted stuff that you can access without circumventing anything, just by, I'm thinking of DOS commands, also my age, but just by double-clicking on the window and accessing the files in the CD. So making that distinction, they found there was no violation of one branch of the DMCA, but nonetheless there was violation of the other. Importantly, though, they found that just because there was a breach of contract, there was not an infringement of the underlying copyright. That's important, of course, because the remedies you get for contractual breaches are different from the remedies you get for violation of a proprietary right, the most important of which are injunctions. It's much harder to get an injunction if you haven't breached a proprietary right. And also statutory damages, because you can get those if you violate copyright, but not if you are just liable for breach of contract. Yeah?
I'm just wondering about the copyright in the dynamically played game, where you're saying that there is no copyright in that dynamic generation through the playthrough?
No, there is copyright in the dynamic generation, but to get to that copyright, that does require circumventing Warden, because you have to actually play the game. But there's also a bunch of graphic files and other things in which copyright subsists that you do not have to circumvent anything to get to. I mean, you can just double-click on the city icon in Windows, and you can see all these files and see all these graphics. To copy that, you're not circumventing anything. So getting to that stuff does not violate the DMCA, but getting to the copyrighted work that only is generated when you actually play the game, getting to that would result in a violation. Any more questions? Okay. Another case, this one goes to the exhaustion doctrine that I mentioned earlier. Werner and Autodesk. So here, the plaintiff owned rights in, I believe it was AutoCAD software. People would go and purchase a license to the software, and this particular defendant, tried to resell the software after he was done with it, I believe on eBay, some site like that. And the rights holder didn't want this to happen. And in the license agreement, this was the language that was present. So when you upgrade, which is usually when you are going to get rid of your old software, when you upgrade, you can't resell your old software. You have to destroy it within 60 days. Also, you can't use the software outside of the Western Hemisphere. And the court found that the rights holder's argument was valid. The software was licensed, not sold. Exhaustion only applies if software is sold. If it's licensed, rights aren't exhausted because there's been no sale. So the court says the software users are licensee because these various conditions have been imposed, and therefore they have to abide by the terms of the license agreement and can't resell the software. So these last two cases, not so much of a nexus with copyright, but or the DMCA, but nonetheless a contractual limitation on how you're going to play a game. So here, Blizzard versus in-game dollar. Perhaps this person used a bot. Reminds me of Scrooge McDuck, sitting on his money bin.
Is that a derivative work, and does Disney have, in fact, an option of going after for copyright? Because there would certainly be copyright in Scrooge McDuck diving through his money money for.
Yeah, but they're just sitting on gold. There's no bin, there's no duck. I think that's fine. Who would not love to sleep on their giant pile of money?
Small.
Yeah. So here, basically, what was happening was the defendant was allowing you to purchase virtual currency. In a nutshell, if you didn't want to spend all the time earning the virtual currency, you could go to their website or exchange or whatnot and buy lots of gold. And what is the contractual language that prohibited this? You have it here. You can't exploit the game for any commercial purpose, and if you're making money selling gold to people, even virtual gold, you're making money off it. It's commercial. Also, commercial solicitations, advertisements, or goods and services available outside of the World of Warcraft universe. Application is fairly evident. Whoops. There was actually no decision rendered here. It was a settlement where, basically the virtual gold exchange was shut down. And again, like we discussed earlier, I think gamers were generally on board. If you're going to spend all that time playing the game properly, you don't want some guy who happens to have more money than you just being able to beat you because they bought all this gold and can now buy up all the toys. In this game, or this case here, Zynga and Nebraska was about online poker. Same sort of idea. Nebraska ran a number of websites that sold for real money, virtual money. The terms of service prohibited this, and again, you had a consent judgment. I was actually down in Silicon Valley earlier in the year, and I spoke with a lawyer who works for one of the gaming companies, and he raised an issue about how when you are doing this exchange between virtual and real money, how you actually have to be aware of banking regulation because you are sort of creating money from nothing. So that's also something to consider that I have not seen litigated, but perhaps it will be, especially with Bitcoin becoming more and more prevalent.
Yeah, and there are various articles in News of the Week over the last couple of weeks related to Bitcoin and various jurisdictional issues that lawyers are calling forward.
Yeah. They opened up their exchanges, because they're opening up exchanges here, right?
Yeah.
Are they open yet?
I don't know.
They are?
Yes.
They are, okay. How much do you own?
I don't own anymore, but I traded for a bit.
Okay. It's still a very volatile market, right?
Yeah, quite.
Okay. So that is the part of my presentation on contractual language and video games. Are there any questions or comments about that before we go to the troll portion of the presentation? Yeah.
With the VNetD case, it seems like the issue is mostly that the service actually went in and modified the code of the game and created this parallel service. And so that violated the copyright in the code of...
The service would not have actually modified the code in the game. I mean, the game would have been distributed on a CD, installed on someone's hard drive, and the service would have been operated on a server remote from that. I suppose theoretically it could have modified the code, but I don't believe it did. What happened was the competing service, did not implement an authentication that required only authentic versions of the game, or that allowed only authentic versions of the game to access the service. So the BattleNet service, the authentic one from Blizzard, would only allow legitimately purchased versions of the game to access the service. The competing service would allow anybody.
Right, and the reason why I'm curious is because are a few services out now. One of them is called Game Ranger, and it doesn't actually modify anything to do with the game. It just uses some of the protocols within the game for connecting the players manually, but it does it automatically through a different client. So let's say enter a lobby, and I'm in a lobby with 5 or 6 different people.
Yeah.
It will automate what would have been a very difficult manual process for putting together those 5 or 6 people. And what that does is actually circumvents the need to authenticate my CPU. Because if I install a cracked copy and I connect manually to somebody else, it doesn't have that authentication process. So what this effectively does is it creates this parallel service.
Yeah.
It seems like these companies haven't taken action against them. And I wonder if that's because, well, I'm sure it depends on the contractual terms, but I wonder if it's because all it's doing is it's automating what would otherwise be available, though not feasible.
Yeah, there is case law about how if you have really what's an ineffective access circumvention mechanism, you're really not circumventing anything when you get around it because it's a totally non-practical or non-usable mechanism. So, I mean, I don't know about that case in particular, but if you're looking to look into that further, that may be the legal reason why no action's been taken. Otherwise, sometimes no action's taken just because no action's yet been taken.
You've been talking about the DMCA,
Oh, yeah.
and obviously it was fairly controversial, and there's been exceptions and a variety of things that have been developed over it. But the latest copyright Modernization Act in Canada has a DRM management sort of thing, which is at least reputed to be even more severe than what the DMCA for infringement of breaking into those protocols or anything like that.
Right.
Do you think that that would be something that would lead to more litigation here in Canada under the new act or not?
Well, theoretically, yeah. I mean, you're right. We have those rules. I mean, the issue with litigation in Canada is just the economics behind it. I mean, we've got 35 million people as opposed to 350 million people, and the lawyers are not a tenth as cheap. So, I mean, that's a very practical reason why people aren't suing, but the cause of action is there. Yeah. Any more questions?
One comment about why, in answer to Matt, there might not be a lawsuit is because fans and users and gamers can be alienated, and companies have to weigh the pros and cons.
Yeah.
And we will use the Davidson case and the BNETD case interchangeably. They are the same case. But certainly Blizzard was taking a risk in what they did in the Davidson case. And not everybody would have been a fan of Blizzard for having done that. But Blizzard was the only game in town. As things get more competitive, and if a company feels more vulnerable about its game, it may be more risk averse in terms of starting a lawsuit that would alienate its core audience.
Yeah, definitely. Okay. So moving on to the troll part of the presentation.
You have 8 minutes.
Okay. Very respectable looking troll lawyer. I mean, so what's troll? You probably see headlines or come across them on the internet. Basically, it's a company whose primary or only business is to sue people asserting patents and to collect fees. They've come into prominence over the last 10, maybe 15 years now, particularly in IT. Why? A few reasons. One, late 90s, roughly around then, you started to get business method patents and some favorable court decisions allowing patents in software/business method fields that are enforceable as they're being enforced now. There was a dot-com economic boom and bust. So the boom, you would have had a lot of companies that were legitimately conducting business, applying for these patents. The bust, they would have gone under and sold the patents to people who were not interested in legitimately conducting business. And you have a lot of very good litigators working on contingency for patent trolls, which makes the business model economically feasible. A graph about business method patents by year, and they're closely related. Most of these are implemented in software. So you can probably use one as a very rough proxy for another, at least for the purposes of this discussion, I will. So it goes to 05. You can see applications filed, big bump, around 2000, dot-com boom. Eventually, the allowance rate lowers, but we're talking about a rate, and we're talking about absolute number of applications. So your total number of issued patents is going to be increased. Indicative of the problem, here are troll, PAE's, patent assertion entity, troll suits from 05 to 2012. Light blue is trolls, dark blue is non-trolls. So clearly, I mean, in 2012, this is the US courts. 62% of commenced litigation was commenced by trolls. And here are persons named as defendants by patent assertion entities or trolls. Again, light blue related to trolls, dark blue not. 63% in 2011, 59% in 2012. It's a growing and significant problem. It's eating up a lot of resources. So what's the response to a lot of this? And this is a real problem. When I was down in the Valley talking to people who work at these gaming companies, you know, they're generally not pleased. So what's the response to this? There have been a few. One, the law, and by law I mean jurisprudence, court decisions has evolved, at least partially in response to patent trolls. It's easier to invalidate patents as obvious, easier than it was 10, 15 years ago when everything started. It's harder for someone who doesn't actually conduct a business to get a permanent injunction. And when you're conducting patent litigation, the injunction is always the hammer the defendant is most concerned about. I mean, if you get an order against you for royalties, that's an inconvenience. It's not going to stop your business. An injunction will stop your business. Statutory response, there's a new American Invents Act, which was the first major U.S. reform of patent law in, I think, decades at least. It made it so that if trolls want to sue multiple people, which is usually what they do, they sue a whole bunch of people in the field. They have to start multiple suits, which is more costly than just naming multiple defendants to one suit. There are also new ways to challenge patents without recourse to the courts. Invalidity proceedings are very, very expensive, and these new ways allow granted or issued patents to be challenged before the USPTO, an administrative body, so less expensive. I think before Congress still is a SHIELD Act, which, among other things, requires trolls to pay full costs and post bond in advance. Of course, the U.S. has a pay-your-own-way system. So if you're a troll and you want to sue 100 people, you really don't have to be worried about getting 100 cost awards against you. You have much more certainty in advance. You know, contrast that to our system, of course, where the loser eventually pays some of the costs. And there's been an executive response as well. If you Google White House Task Force on High-Tech Patent Issues, President Obama has 5 or 6 different points that he can implement using his authority, and they've done that. I haven't noticed any difference in practice, but perhaps eventually. And just a couple quick examples. And here these examples are to take what is commonly said in the media and to show you what actual language they're talking about. So there's one suit, Game Tech versus everybody. One media report I read said the patent would seem to cover the common practice of using virtual currency to obtain items in the game. Whoops. That's actually what the patent covers, so it's a little more complex than that. Another case directed at said the media, an online authentication system that enables users to verify and access their data on a portable licensing medium. There, apparently a much broader claim, so perhaps in practice a little more problematic. And to conclude, so where are we in terms of the balance between contractual law and intellectual property? Do we have too much of one, too much of the other? Is it just right? How would you balance it? How would you rebalance it? Was there ever a sweet spot? What should be changed?
Do you want my answer?
I know your answer. What should be changed? We went through some of the jurisprudence, the legal responses, statutory, legislative, executive, judicial. What else should be changed? That was with respect to patent trolls. What about with respect to the intersection of contracts and IP with respect to video game law? The courts are reacting to the times. Have they kept up? That's a big knock on courts. It takes forever to get anything done. It takes forever to get any kind of response, especially in a high-paced, technologically innovative world. Are they doing a good enough job? Can they be doing a better job? If so, how? Just things to think about. And that's it.
Thank you.
Very good.
Awesome.
Okay.
This is the one incursion of technology because the camera goes off at 12:20. So we'll take questions. I have some housekeeping things, but in terms of the lecture, for your convenience and for everybody and for editing purposes, so that you have something complete, we will always have to start on time at 10:30 and go to 12:20 because that's how the system works.
Okay.
So we're now off, and you can continue, take questions, and also your presentation.
I'll send it to you.